Well, to a different matter involving the Guptas. Now, the family has lost yet another court battle. This time, the South Gauteng High Court has ordered that business rescue practitioners must have immediate access to their Oakbay servers. The Guptas also need to explain why they should not be jailed for contempt of court. Well, Nicholas Bauer joins us for more on this now. Good evening, Nicholas. Thanks very much for coming through. Now, Judge Unterholt again, and we underline again, ordering Oakbay to give business rescue practice. Do we know why they haven't been, or they've been refusing to do this?
Well, the mind boggles as to why they've been refusing and why they continue approaching the court to try and prevent what seems to be the inevitable. I mean, if this was a football match, Voya, it's 7-0 now that the Gupta-linked companies that were placed under business rescue in February have challenged the legality of the business rescue practitioners, which they themselves had a hand in appointing, being given access to the premises of these businesses, and of course also being given access to the business records. What's in question essentially is a server at Oakbay Investments headquarters just down the road here in Sandton. Now, Oakbay Investments is the holding company for a lot of these companies that were placed under business rescue, the likes of Tegeta Resources, Oakbay Resources, Island Site Investments, Confident Concepts, and the like. And essentially, in a quite puzzling move, because they appointed business rescue practitioners to try and breathe life and resuscitate these businesses which are allegedly on the brink of collapse. And then essentially, when the business rescue practitioners went about their work, they obviously touched a raw nerve and as such were thus barred from the premises and specifically barred from a room where the server of Oakbay Investments stands.
Why is this server particularly important? Because I understand there's a lot of quibbling around the meaning of unrestricted access.
Well, look, essentially what the Gupta-linked companies have been arguing in court is that the business rescue practitioners are overstepping their mandate in terms of accessing a server that doesn't only hold the company records of those that they have been tasked with saving, but also those in the others within the business Gupta business empire. So you can only think what's on that server that they wouldn't want to fall into the wrong hands. And speaking to the attorney that is representing the business rescue practitioners, Bauer, essentially intimating that they're trying to hide nefarious things that may come to light if business rescue practitioners are allowed on the server. But at the end of the day, I don't know how they're going to challenge this, and I don't know how they're going to prevent business rescue practitioners from not only being on the premises, but also accessing these business records from the server itself. Judge David Unterholt, unequivocal in his judgment today, referring specifically to the room number even and the address of the premises to say you need to give access specifically to the server room where this server stands. And perhaps most worryingly for the associates linked to these Gupta companies is that they need to provide an affidavit within the next 30 days explaining why they failed to uphold a court order on several occasions or be held in contempt of court and face jail.
Well, you've introduced another puzzle, because if the rescue practitioners were appointed by the
turn on himself and end up biting the hand that feeds you. But essentially, you can only suppose that this is the case at this stage. Why else go to court 7 times to try and prevent what looks like is going to be inevitable now, where you have to grant access to the premises, you have to grant access to the server. And as such, when we left court at about 2 o'clock today, we haven't been able to confirm whether or not these business rescue practitioners have gotten into the server, but I was told by their attorney that they only needed 3 to 4 hours to access all the information that they needed. And if they come out and further information comes to that maybe doesn't put the Guptas in a good spot, when already they're in a very, very challenging position. One can only imagine what the Guptas are going to be facing in the weeks and the months to come, as really, as every week passes, their empire essentially crumbles.
Very quickly before I let you go, remind us again, why was Oakbay to get Shiva uranium put under rescue in the first place?
Well, essentially, if you put it down in layman's term, a business is only put under business rescue when it has a serious chance of failing, of collapsing, essentially. And you can apply for business rescue if you're close to bankruptcy, or essentially you've lost the means to actually conduct business. The main bone of contention there is their inability to actually find someone to bank with. And this is one of the main things that the business rescue practitioners have been tasked with, to get their finances in such in order that they can go and find someone else to bank with besides the banks that have already closed their accounts, and of course, indeed, as well, the Bank of Baroda, which was the last man standing in a sense.
Well, let's leave it there for now. Thanks very much. Nicholas Bauer, who was, of course, at court today.